for the Visas.AI webinar and attorney Collab. We're very, very happy to be discussing EB-3s and EB-2s today. I will give you the mic, and I'd love to know how far have we come in our previous conversations, and what we're going to cover today.
Great, Pierre. Thanks so much. So we've been doing a series, which I don't, we'd like to continue on for the EB-2 and EB-3 labor cert process. Those are green cards, also known as immigrant visas, and the labor cert process is where employers sample the job market to determine if there's no Americans willing or able to do a particular job or jobs. And then if they find that there are no Americans willing or able to do the job or jobs, then they can apply to USCIS. Well, first to the Department of Labor through an ETA 9035, isn't it? And then to if that comes back approved, then they would file the I-140. So we've talked about the prevailing wage, which is where you find out what the government believes for your county and state the wage needs to be, the minimum wage for a particular job. And then after you obtain that, then you do recruitment, and that's where you advertise in 5 different ways, and that's where Americans or green card holders could apply for the jobs. And if they don't meet the minimum requirements, and we talked about techniques you can use for the minimum requirements on our previous webinars, then you can apply to the Department of Labor for what's called a labor certification, which is where you certify that you sampled the job market for this scenario. And we talked about a lot of those things. And then once the labor cert comes back, then you would file the I-140 with immigration. So I think we stopped at the filing of the labor cert last time. So I want to kick it over to Ashley to either remind us of what we talked about last time or take it a little bit farther into what are some of the issues in the 9035, some best practices, problems, what might create a request for information, and how to handle that. And we'll.
Yeah, so I thought we had only gotten through recruitment, but as we're talking about this again, I'm remembering that I think we did get into the 9089 because I think we talked a little bit about how important it is to have everything match up. So everything that you're going to put in your 9089 needs to match everything that you've done thus far. Exactly, and they will.
So those matches are the prevailing wage language,
and the
in all the different places.
language.
And then the deal, and what needs to match are the requirements and the duties, right?
Right.
What
and then you have to be real precise on, when you ran those ads and make sure all the dates are correct. Because if you do receive an audit and you accidentally put August 23rd instead of the 22nd, you're gonna have a problem. So it's very detail oriented. Some of the issues that you can run into are for the ads in recruitment, they're charged by the character or by the word, depending on which service you're going through. So people a lot of the time want to cut that ad language down in order to save money during recruitment, which is reasonable and makes sense. You have to be very careful about that though, because if you cut out important things from the ads, then you're not going to be able to have everything be consistent from the PWD to the advertisements to the 9089.
What's the logic that they use when they have problems with the prevailing wage not matching the recruitment, which are the ads, or the 9089?
So they being the Department of Labor would say that you didn't give a sufficient notice to the U.S. public to accurately determine if there was a U.S. worker that was available and able to take that position. So if you left something out of your advertisements, whether that was a travel requirement or that you need to speak a certain language or anything like that, then they'll say that the U.S. Public wasn't made sufficiently aware of this job opportunity.
Great. Thank you. Okay. And so what are some instances where things have been left out that have come back to haunt practitioners in companies?
Yeah, so there's a lot of cases where people have left out a travel requirement, or they've included it in the PWD, but they didn't include it in recruitment, or they included it in the PWD and recruitment, but they didn't include it in the 9089, or they didn't include it in either of the first ones, and they did include it in the 9089. Any sort of inconsistency, whichever you left that requirement out of, can cause an issue. There's been a lot of like case law on this, where they're arguing that just because it didn't say that they required travel, it's actually making it available to more people because some people might not want to take a job that requires travel. They determined that argument did not work. There was one case where the petitioner won, because it was for multiple positions. This was the Microsoft case. I can't remember the entire case name, but it was a Microsoft case, where they put out a recruitment for multiple positions. Only some of those positions had travel requirements. So when they went and filed the 9089, they didn't list the travel requirements, and they were able to overcome it and win their case because they said for this specific position, there is no travel requirement. For some of the other positions, there are.
That was a very narrow win, as I
There
recall.
has
Yeah.
been the travel requirement situation. So it's no long. It's one of those things like what John mentioned in one of the previous episodes, where it doesn't cut it anymore just because you can't find someone in the U.S. that doesn't want to travel. That's not enough reason to
Yeah, that's
justify a foreign national.
what
Is that
happened,
correct?
Pierre, on that is that there was so a lot of us represent companies that hire Indians, and Indians are big in the tech market, and our tech market relies on them. Well, India has such a large population in so many cases that they're backlogged. So there are priority date delays, meaning that an Indian national, or even anybody born in India, even if they become a national of Canada or something else, still has to use the India uh, uh, annual allotment, which is backed up, and it's backed up 12 to 15 years. So the companies that are sponsoring their visas might move, right? And so a tactic that has been used by attorneys representing these companies is to say that there might be unanticipated travel required, and that unanticipated, what isn't that what it is, Ashley?
Various unanticipated locations.
Various unanticipated locations. Sorry, various unanticipated locations is what you put in if the company moves from one part of town to another part of town because it's connected to that company. So then, Department of Labor has been issuing requests for information on to describe specifically what these unanticipated um, locations are, and they're unanticipated, right? So you're sort of a damned if you do, damned if you don't, and if you can't explain that, which you wouldn't be able to if you didn't know where you're going to move before you knew you're going to move, then your case could get denied. So one of the things that attorneys have had to hurdle recently is when they put those in earlier in the cases, maybe at the prevailing wage or even in the ads, and then knew that they were going to get this, then they wouldn't put it in the labor cert or wouldn't put it in the ads, but it in the prevailing wage. And then immigration has come down and said, this has created an issue that eliminates Americans or is confusing to Americans who thought they may have this unanticipated location that they may have to go to in the future, and now they don't, and therefore the case gets denied. And one of the hand wringing that goes on in immigration of, well, how do you handle that? So that's an issue, Ashley, you've handled recently, isn't it?
Mm-hmm. Yep. Yeah. So the RFIs that they're issuing at the prevailing wage determination stage, which came out of nowhere, there was no statement that they put out that said they're going to be looking into this or changing. People have been using the language various unanticipated locations for at least a decade with no problems. But now they're issuing requests for evidence requiring you to state, as John said, where the travel is going to be, the frequency of travel, why you're traveling. And that's a hard question to answer when you're just putting that language in as just in case your office moves and you don't know where the office might move.
to change gears a little bit, but staying on the 9089, business necessity. So business necessity is a tricky wicket that an inexperienced attorney may not know they're walking into. So there's a thing called an SVP, Standard Vocational Preparation, and it's issued on the ONET website, and it tells you what the SVP rating is. And if you what you really are doing when you're trying to make requirements for visas is not to tailor it to an individual too closely. And some red flags are speaking a foreign language, things that are very obscure requirements that have nothing to do with something, but our person happens to have it, and you can't just eliminate them that way. And you're tight-roping with what's the standards. Well, what the SVP tells you is for this type of job, the standard might be, say, a master's degree or a bachelor's plus 2 years. And so if your job requires more than 2 years, a bachelor's plus 5, for example, you need to explain in the box for business necessity why your job needs those additional 3 years from the SVP. So if you don't know what SVPs are and you're just putting, my guy has 10 years experience, I'm going to say he needs 8 and we're good, they'll come back on an RFI and say, why is this there? And so it's better to get out in front of it in the business necessity component and say, this particular job needs 5 years experience because, say, for example, they're a developer, they're doing, they do development for banks, international banks that have millions and billions of dollars in it, and they really need to know this security technology better than somebody with just a master's degree or a bachelor's degree plus 2. Something along those lines would be what a business necessity might need to be. Ashley, do you have any input on business necessity?
No, just that's another recent change where they've changed the 9089 where you explain that upfront now. Before, if they saw that you exceeded the SVP requirements, they would issue you an audit and you would handle it at that point. But now that the form has changed, do they want you to address that upfront?
Right. And the form has gotten smaller, and one of the challenges for lawyers are the number of characters available to type in there, and that's giving some people some fits, right?
Yeah. Yeah, and also with the linking of the PWD, before you would have to go in and manually put in all the information from the PWD, the wage and the location, and even the PWD number, everything that's on the PWD. Now it links automatically, but there's been some issues with not having it linked, and if you've switched attorneys halfway through, sometimes that PWD is out of network, and you should be able to link it. The system can be cumbersome.
So let's talk about that. It's kind of a housekeeping matter, but what is the system that you file all of these documents through now?
Flag. And I used to know what that acronym stands for, but
where is it found? Can you give us a website address?
Yeah, it's flag.dol.gov.
Okay. And what goes there? And you talked about linking. What does that mean? Can you back it up a little bit for a company or an attorney that may not have done this before?
Yeah, so you file the PWD or the prevailing wage determination through the flag portal as well. And then later, when you file the 9089, that's also through the flag portal. You can type in, if it's for a case where you're using a PWD, you type in the PWD number, and then it will pull up that case and kind of auto-populate everything from the PWD into your perm or 9089. Which in theory should be great and it saves you doing, some additional data entry, but there are some issues that come with it occasionally if you can't get those things to link up.
Excellent. Okay, so we filled the 9089 out to best of our abilities. We make sure that there's a business necessity. If there needs to be a business necessity, we probably remove the unanticipated locations that we used to put in there. We make sure that the language for the duties and requirements of the job are the same that was in the advertising and the prevailing wage, and we submit it. What happens if Department of Labor has a problem and issues us a request for information or an audit? Take us through what those are and how we should handle those if we get one?
Yeah, so you should always be prepared for an audit, because they can even issue it, down the line. So in order to prepare for an audit, we do an audit report, or an audit memo that lists every applicant that they've had to the job, whether they interviewed them, if the person wasn't qualified, basically why did they not hire them if they didn't hire that applicant. So that is all recorded, kept on record, along with proof of all of the ads that you submitted, because on the 9089 you're just putting the newspaper name or the radio station name and the date that it was run. But you're not actually providing the tear sheet from the newspaper to prove that you've done it. And if they audit you, then you would have to provide it at that point. So keeping that all organized and on file is super important in the case of an audit.
Cool. Okay, so I've heard stats like if you get audited, you have about a 50% chance of approval, and it'll take a year and a half longer. Are those still accurate, or what are your thoughts on life after audit?
In terms of the timeline, it can take up to that long. The DOL has been really inconsistent. Some of them they're getting, they're turning them around quicker, and some of them are taking that long. In terms of approval ratings, I don't know if we're just doing a really good job, but we have a higher than that number approval.
So with audits, they're looking at how you advertised, and while you don't have to put that stuff in with the 9089, you have to keep it, right? So if you are audited,
right,
show who came forward, how you decided to disregard them, and that sort of stuff, right? What is there something that if they don't like what you're doing, that they may put some further sort of oversight on you to deal with this?
Yeah, I think that happened to, if we're talking about the same thing, to Fragaman back in the day, where they were, I can't think of it, supervised recruitment.
Yeah, supervised recruitment. Yeah. That's where they think a company may not be doing their recruitment correctly, right? And then so what is that, where you're working directly with DOL to...
yeah, they're overseeing everything that you do throughout the process, which isn't great, hopefully.
Very good. Okay, so say we did everything right and we didn't get an audit, or we got an audit and it came back successfully and we have an approval. What happens next?
Next, you would file the I-140, and depending on where that person's country of citizenship is, and where their priority date is, if they're current, or their priority date is current, then they could also file the I-485 concurrently with the I-140. A lot of people, particularly those from, I think we talked about this already, India, the Philippines, China, they'll have to wait a significant period of time for that priority date to become current in order to file their I-485 or adjustment of status, which adjusts their status to a permanent resident or gets them a green card.
Yeah, and I think one of the takeaways, one of the nuggets that inexperienced lawyers may want to understand, and don't learn this the hard way, is make sure you get your proof of what the beneficiary has accomplished to meet those criteria at the beginning of the case, and not wait till the I-140, because your person may have said, hey, I've got 2 years experience in the job, which is what the requirements are, and I can get letters, and you're like, you go forward, and then when they get those letters, they can't get one of them, or they're learned that that was a part-time job and you didn't think to ask them that, and part-time jobs only count part-time. So 2 years experience in a part-time job is equivalent to 1 year experience. And if you made the requirements, which you as the lawyer get to help determine, you've just made requirements that your own client can't meet, and they'll be denied.
And by that time, you've been doing this for, over a year. They have a bunch of money invested because they've already done recruitment. It's horrible when you get to that point and that happens. Because up until this point, when you do the PWD, when you do recruitment, when you do the 9089, those requirements are listed on all of those, but you're not required to prove them until you get to the I-140 stage. Even on the 989, it asks you to list the beneficiary's work experience and education, but you don't actually provide any proof of that, like the
Right.
degree or the experience letters, until you get to the I-140 stage. So you've already listed for the government all of the beneficiary's experience, but
Yeah.
when you get to the I-140 stage, that's when you have to prove all of that.
Yeah.
You're talking, but you're on mute.
Talking, but muted. Yeah.
Thank you guys. So there's a question from the audience in YouTube asking if the job has to be full time and permanent. The job offer, I'm assuming.
Well, it would be permanent. But Ashley, what are your thoughts on a part-time perm case?
I haven't done any of those. I know there's a question on the form that asks you if it's full-time or part-time. So I assume that you can do part-time. Every single one that I've done, and I've done hundreds and hundreds, have been full-time.
And
Never
what
never
does
seen one
permanent
come.
job
I
mean?
did. I was addressed once on seasonal with ski instructors, and it can't be seasonal because that's not permanent. So
Mhm.
from H2Bs or H2As to the EB3 is difficult if the job's seasonal. If you can't show that there's a full-time job or
And
a
when you guys say
full
permanent,
season
by
job.
the way, what
Permanent.
does that mean? So it has to say on the job offer that this is extended forever. Is
Well,
there
no, it
something?
just can't have a term to it.
Okay.
Yeah.
So permanent visas, look, there's no slavery or involuntary servitude required with the job, but non-immigrant visas, the alphabet soup, the P's, the O's, the H1Bs, H2As, those are all temporary jobs that have to have start dates and end dates. The green cards are in perpetuity or until they end, right? So, but they don't have a designed end date. And that if you put one on it, you would get your case denied, right? And just like in the H1Bs, if it doesn't have a term, it would get denied. So it's just things you got to know. So yeah, it needs to be a permanent job, but obviously you can do that. Now, one of the things people say is, do I have to stay there forever, or do I have to keep that person employed forever, right? No, but that what their immigration tool is looking for is fraud. So, did you fake a job and commit fraud against the government to get somebody a green card? Could be a question if they never work there. So, what would be a good best practice is to hire somebody and let them work for maybe 6 months, and then at
After they
that
get their
point
green card.
by that point, you can make a decision that they're not a fit or whatever. But we brought them in. We did what we said to the government we were going to do, and that was to hire somebody. But it's not working out. So obviously, anything less than that may make questions arise. That's a safe amount, but obviously, probably not a good idea if they work for a day or a week. So. Um, do what you said you're going to do, and then if it doesn't work out, move on at that point.
Makes sense. Thank you very much.
Yeah, so we're a little over, a little past the time now. Is that right?
Yes, we are. And so
Okay.
to wrap up, I know you guys have very busy schedules. To wrap up, I just any closing thoughts from you, Ashley, and then we'll go to John. Any closing thoughts on this and what you think about what we discussed today?
Yeah, my closing thoughts are always the same when it comes to EB-2s and EB-3s in the perm process in general. It's a really long and complicated process. There are some visas where you could probably do it yourself. This is not one of them. This is one where you definitely need an experienced lawyer to hold your hand through it because there's so many traps throughout this very long process that you can fall into.
Yeah, I think most of us have done it, have fallen into those traps, and education's the best teacher, right? So trying to get somebody who's not an immigration attorney to do this just because they're an attorney would be very difficult. And immigration attorneys that haven't done these routinely make mistakes. There's just too many to make. So anyway, it's a good thing to do. Hire somebody that knows what they're doing on this. Talk to them. Have them take you through the whole process. What are the different steps? How long does it take? What are the expectations? What do you need from us? Who needs to pay? Those sorts of things are really critical.
Excellent. Thank you, Ashley. Thank you, John. We'll see you in the next webinar.